Hello students, welcome to my channel. Today we are seeing about the SARFAESI Act. So in this series of bank SO preparation, I'm going to talk about the SARFAESI Act today. In specific, Section 13 of the SARFAESI Act, that is the enforcement of security interest. So as a law officer, you might come across questions regarding the Section 13 of the SARFAESI Act, which is essentially an act passed in order to ensure that the banks are able to enforce their security under loans to have a quick recovery of the NPA. Now we all know NPA is a very big concern for banks in India, the non-performing assets. And to recover these non-performing assets, the government has come up with the SARFAESI Act, where the bank themselves, without the intervention or with minimal intervention of the courts, can enforce the security interest. Now, one of the most important aspects of the security interest is the Section 13 of the SARFAESI Act, which gives a detailed procedure. Now, we have to read this along with the SARFAESI rules as well. Now, I'm going to talk today in this video only about Section 13.2, which will be helpful for you for your interview preparation. And in case you are preparing for mains as well, keep this point in mind. Now, what is the overview of Section 13? Now, like I said in the beginning, the SARFAESI Act in itself is an act which gives a fast track mechanism for the banks to enforce the security interest. Now, the enforcement of security interest is given under Section 13. Having this much of knowledge itself is a big plus, because in interview, if an interview asks you questions of which section gives the power for the banks to enforce their security interest, then you can simply straight away go ahead and answer it as Section 13. Now, the next question coming is, how does the Section 13 is framed, or how does the Section 13 is structured, so that the banks using their authorized officers, when I say authorized officers are the officers under the SARFAESI Act who are essentially in the rank of scale 4 and above in the banks. In banks, usually there are various forms of scale. It is a gradation process. Like for instance, if you are entering the bank as a fresher, after becoming a PO or an SO, you would be in scale 1. Then subsequently, you will climb the ladder, that is scale 2, scale 3, scale 4. And in SARFAESI Act, in order to be an authorized officer, that is the officer who would perform all the functions, procedural functions like issuing notice and taking valuation, and all these things will be done by an authorized officer, and his rank should be at least scale 4 and above, that is shift manager and above. Now, when I talk about the overview of Section 13, it allows the secured creditors, it allows the secured creditors to enforce security interests without court or tribunal intervention. Like I said, generally without court or tribunal intervention is fine, but there will be minimal intervention of courts. Like for instance, in case if the property is not not in complete physical possession of the bank, or if someone is living in the property, or if the mortgager has lent the property to a tenant, then there need to be an eviction process, and for this a minimal courts in permission is it's not like a permission procedure is needed. For you have to go to the DM or the judicial magistrate to get that permission. That we will see in Section 14, but right now I'm focusing on Section 13 and how to it governs the process of recovery of secured debt, as I said, the default, and it empowers creditors to take possession, manage, and sell secured assets. So this is a general over how it is done. Now, like I said, first we must understand the process in banks. The banks lend money, especially for a collateral like a security. Usually if it is a home loan or a business loan or anything, it will be backed by land or house or anything as collateral. So now when the loans are not repaid, when it becomes an NPA, that is non-performing asset, then the banks can sell this security in the market either through public action or private treaty, and uh, appropriate the proceeds against the loan in the form of recovery. Before the enactment of SARFAESI Act and the DRT actually came up in 1990s and the SARFAESI in 2000. The banks did not have this luxury. The banks have to follow the normal redemption or normal mortgage process under the civil procedure, which is itself is a tedious and a time consuming and a dragging process, which had a great effect on the economy. Now, how does this happen? So, one of the first things in section 13 is the section 13(2), which gives the procedure for to issuance of a demand notice. Now, once the account becomes NPA, that is as per RBI guidelines, if the account if there is no money, no interest or principal paid in the account for 90 days, then the account will be declared as NPA. Once the account has become NPA, the first thing that the bank should do is they should issue a demand notice, and they will give the demand notice should give 60 days to discharge the liabilities. Now, within the 60 days, what can happen? So, usually I'll give you this simple overview. Usually, the bank, that is, demand notice will be issued, and who will be issuing the demand notice? That is the authorized officer. The authorized officer would be a person at least of scale rank 4 or above. So, he will issue a demand notice, and the demand notice will give time for at least 60 days. Now, during the 60 days period, the borrower can represent to the bank, say, can ask for time or can give a representation why he is not able to pay, or any sort of representation. The banks is duty bound to answer that. Say, for instance, I have a demand notice has come across me, and I am giving a valid reason saying that I have some business losses, something, I'll pay it a little bit later. Then the bank should reply to it within 15 days. This time frame we will see later, within 15 days. And if in 15 days I have replied, say for instance, first 60 days time is given, and within 60 days, if the borrower replies to that bank, then the bank has to reply to that representation. It is not necessary the bank should delay the process. They can also just reject the representation, say that if no further time would be given, and we would go ahead and enforce the security, that is, sell the property as collateral. Now, the question here is how a demand notice, what the demand notice should have. Now, what kind of interview questions can come here is, what is the time period given under section 13(2)? That can be asked, that is 60 days. Now, demand notice, like I said, as per 13(2), demand notice it has to be issued. Now, what should this demand notice contain? This is very important. Like I said, SARFAESI in itself is a procedural law. And being a procedural law, if there is any deviation in the procedure, then the borrower can approach DRT and get the action temporarily stopped or even completely nullify the action. So, in this case, it is very important to understand how a demand notice should be there. Now, what is a demand notice? Like I said, it is issued under section 32 of the SARFAESI Act. It is sent by the secured creditor to a borrower and default. And who sent this? You must understand it is sent by the authorized officer. Understands? And what is the ranking of the authorized officer? It is scale 4 or above. And it provides borrower with 60 days time to repay the debt. And it is the first step in enforcing the security interest. Now, how to serve a demand notice? It could be served under registered post, speed post, courier, electronic max or fail, electronic mail or fax. So, all this process is very important. And when you serve this demand notice, it is essential that you keep a record of it. You keep the record of receipt. It is usually good practice to send it through speed post, where there is a proper tracking, or to the registered post. And in case if the authorized officer comes to believe that borrower is deliberately avoiding the notice, then he can affix in the borrower's premises. That is, the demand notice can be affixed in the conspicuous spot of the premises and published in two leading newspapers, one in vernacular and uh, one may be in English. Say, for instance, if it is Tamil Nadu, the vernacular language is Tamil and one can be in English. Now, this is the most important thing. What should the demand notice, contents of the demand notice? The contents of the demand notice is, first, it should mention the total amount due from the borrower. There should not be any ambiguity. The total amount due from the borrower should be mentioned in the demand notice, and it should be a proper method, proper accounting principles should be followed, and the bank cannot uh, do any mistakes here. And even if there is a mistake there, then your SARFAESI action can be declared null and void by the DRT. Next, description of the secured assets, that is very important, description, because this is another area where a lot of cases, a lot of disputes, a lot of litigations have come up. That is, say for instance, the flat name may be F1, but if the description of the assets in demand notice it is written as F2, even this minor clerical mistakes can vitiate the SARFAESI proceeding. So it must be a proper description of the security assets that is intended to be enforced, whichever is, whether it is mortgage or is hypothecated. So the description of the security assets is very important. And it should also refer that in case if you pay the money, then the borrower has every right to redeem the property. And note, the borrower can redeem the property only till a sale notice is issued. We will see the when the sale notice issued in the further videos, but so far we are talking about the demand notice and the statement on consequences of non-payment within 60 days. And in case if there are multiple borrowers, then it is essential to serve the notice on each borrower individually. And if it is a body corporate like a company or a partnership firm or LLP, then this notice can be served in the registered office or any branch. Like I said initially, 60 days. Now, what are the borrowers' rights? Now, the borrowers can make representations or raise objections, and the authorized officer must respond to it. And remember, it is a 60-day time period. The borrower has to mandatorily send his representation, raise objection within 60 days. After 60 days, then he might not have a good case in the DRT. So he must raise it within 15 days, within 60 days. And for that, the bank should reply within 15 days. If the bank is not replying within 15 days, then that could also be a ground for nullifying the SARFAESI action, and it should respond with proper reasons and objections. See, the borrower has every right to make representation and objections, but the bank, it is with the discretion of the bank to accept it or not to accept it, but they must be doing with the proper reason. That is a little bit of principles of natural justice. That is, proper statement has to be given of why they are rejecting it. Next, the consequence of non-compliance. Borrower, if they fail to comply within 16 days, that is either they do not send a representation or they are not paid any money, then they can take possession of the secured assets and manage or sell the assets. Now, like I said, what is the response? How should the response be? The borrower can raise objections or make representation to secured creditor. They must respond within 15 days. Remember, if the 15 days period has crossed, then this would be a ground for the borrower to raise a defense in the DRT. And the reasons for non-acceptance must be communicated. Like I said, the borrower has only right to make representation. He cannot delay anything further. And the communication of reasons must be done. Now, then going to the measures under section 13.4. Once 13.2 is done, they can go to the 13.4, that is take possession. That taking possession aspect, the bank has to approach either the district magistrate or CMM, Chief Metropolitan Magistrate. Now, after the BNS, it will be Chief Judicial Magistrate. So that we will see in a separate topic. So far, we have seen section 13.2, which is very important, and the contents of the 13.2. If you like this video, do share it, subscribe it, and support my channel. If you have any doubts, please mention in the comment box. I will be happy to help you or clear it. So in the next video, I'll talk about the measures that is needed to take the possession. Like I said, 13.2 is fine as long as the possession is in the bank and the bank can simply go ahead with the next step of sale notice and selling of the property. But in case if the possession is not with the bank, physical bank, then they need to take possession. What are the procedures under that? We will see in the next video. Thank you.